Muted.
Okay. All right, welcome everyone. My name is Andrew Taylor. This is the second of 5 teleseminars, and today we're discussing the financial uncoupling of assets and debts and other financial issues surrounding divorce and separation. Thank you all for listening. We greatly appreciate it. We are Uncoupling, the divorce resource group of Greater Philadelphia, and I want to tell you first just a little bit about us. We're a group of 10 professionals designed to provide information drawing on our particular area of experience as it relates to the entire divorce process. We are committed to providing information and giving guidance to people who are navigating through divorce. Our goal with these seminars is to provide knowledge and dispel some of the myths surrounding divorce. During these seminars, though, we are not offering advice. We are just providing information. With this group, we wanted to create a one-stop shop of professional resources for all issues that may arise during the different stages of divorce. So I want to just introduce everybody in our group. First, again, my name is Andrew Taylor. I'm a family law attorney at Shemtob Law in Bluebell. Allie Collier is an insurance account executive at Johnson, Kendall & Johnson. Elizabeth Butler, a clinical social worker and therapist. Sheila Brennan, a divorce coach. Valerie Clark Roden from Hoteling Investment Management and Wealth for Women. Mark Bradford, who is a forensic accountant at Asterion Consulting. Laura Stagosi, who is an estate planning attorney at Diamond, Polsky & Bauer. Bill Donahue is a mediator, attorney, and owner of Transitions Mediation Center. Ken Feynman, the branch manager of Approved Mortgage Group. And finally, Kay Pugh, who is a realtor at Keller Williams of Bryn Mawr. Our first teleseminar was last month entitled, Should I Stay or Should I Go? And dealt with knowing when it is the right time for you to separate or divorce. If you want to listen to that teleseminar, you can go to our YouTube channel at Uncoupling Philly Divorce Resource Group or on our website at uncouplingphilly.com. In addition, on our website is all of our contact information and bios on everybody in our group. Be sure to mark your calendar for our next teleseminar, which is at 12:15 p.m. on December 3rd, 2015. It's called Two Homes, and during that teleseminar, we're going to discuss issues relating to child custody. Future seminars beyond that one are also on our website. We hope that all of these topics that we're covering will discuss several frequently asked questions that usually arise during the course of a divorce and also provide some guidance to our listeners. We encourage you to submit any questions that you might have before each teleseminar via our website at, again, uncouplingphilly.com. So without further ado, we're going to start today's discussion, and I'm going to lead off. Again, my name is Andrew Taylor. I'm a family law attorney. And again, today we're talking about financial issues related to divorce. So in my experience as a family law attorney, I've seen financial issues being among the highest in priority and the most stressful when going through the divorce process. Knowing what to expect really goes a long way in navigating through a divorce. Most cases go forward on a no-fault basis before you get to a division of assets. So in Pennsylvania, you do need grounds to establish divorce. Again, most are no fault, but you still can pursue fault-based divorce. But bear in mind, if you prove fault, like adultery or indignities, it doesn't get you any more money. So today we're going to briefly talk about dividing assets and liabilities, child support, and alimony. So the first thing that you need to do when going through a divorce is identifying and valuing the marital estate. So what do you and your spouse own? You need to think about assets like, of course, your house, any vacation homes, retirements, pensions, savings, stocks, cars, valuable collections, and also make sure that you have a compilation and understanding of all of your debts, credit card debts, car loans, mortgage, line of credit. You need current balances for all of those as well. So you take all of your assets, basically, and subtract all of your debts, and that's your net marital estate. The marital estate would be the assets and liabilities acquired from the date of marriage through the date of separation. So the first myth I want to dispel is that in Pennsylvania there is such thing as legal separation. There is no such thing. Date of separation is certainly important because, again, that's when the marital estate stops accruing. But the date of separation is presumed to be that when somebody files for divorce or when somebody essentially moves out of the marital residence. So it's important to establish a date of separation, but there is no legal separation in Pennsylvania. And also, it doesn't matter how assets are titled. As long as they occurred during the marriage, then they're marital. So if all of the assets are in the husband's name, for example, it doesn't matter. As long as they were accrued during the marriage, they're still marital and subject to division in the divorce. Next, Pennsylvania is not a community property state. And what that means is that assets aren't necessarily going to be divided on a 50-50 basis. Instead, Pennsylvania is what they call an equitable distribution state. So that means that a judge or equitable distribution master or who's ever dividing up your assets are going to consider many different factors in how to divide the assets. So it could be 50-50, 55-45, 60-40, whatever. Some of the factors that are considered would be the age of the parties, the health, the incomes, whether or not the one parent is the primary custodial parent of the children, non-marital property that each party holds, assets that each party is receiving during the divorce, the length of marriage, and contributions that each party made to the marriage and the marital estate. Division of assets differs from county to county as well. Some counties are definitely more 50-50 oriented. Other counties, it's easier to get a skewed distribution of the marital estate in your favor. And also note that the longer you receive alimony, probably the more likely you are to get a 50-50 division. So some people say, I would rather waive alimony and get 65% of the marital estate. Other people say, I'd rather have alimony and get half of the marital estate. So that's something to keep in mind as well. Child support. Child support in Pennsylvania is driven completely by the incomes of the parties. So this gets a little bit tricky when you have a self-employed individual to find out their true income. Sometimes people who own businesses run personal expenses through their business, so you need a forensic accountant like Mark, who's going to speak in a little bit, to kind of go through expenses and cash flow and determine what the business owner's true income is. But in cases where you have W-2 wage earners, where you're paid a salary, it's much easier. You can put your gross income into a software program and it calculates your net income, and then those numbers generate a child support figure, and each party then contributes a portion of that child support. So the party who's earning more pays child support in most cases, and then there's some add-ons like a portion of private school, daycare, extracurricular activities, and things like that. So this is not a needs-based analysis, which is another myth that many people think. If you spend $5,000 on your children a month during the marriage, that doesn't mean that you're going to get $5,000 a month in child support. It's all driven by income. And a lot of people are surprised during separation about how really low the child support amounts are in Pennsylvania. Next, we'll talk about alimony real quick. There's different kinds of alimony. You'll hear terms like APL, which is alimony pendente lite, or spousal support. Those are temporary spousal support that's from the time of separation until the time of divorce is actually entered, which can be a few years or it can be much shorter than that. But that is a straight formula, again, based on the incomes of the parties. So if you have minor children, it would be 30% of the difference of the net monthly income. So the spouse who makes more money would have to pay the spouse who makes less money. If there's no minor children, then, and no child support calculation involved, then it's 40% of the difference of the net monthly income. So as you can see, it's all income driven. And by the way, Pennsylvania is the only state that has a formula like that. Most states have a needs-based analysis, but again, in Pennsylvania, it doesn't really matter how much you spend on yourself during the marriage. Once you're separated, all you have to determine are the incomes of the parties, and the numbers kind of flow from that. Now, after a divorce decree is entered, we're talking about alimony, not temporary alimony anymore, alimony. And that's based on several different factors. So there's no formula for alimony like there is for temporary alimony. So things a court would consider would be very similar to the equitable distribution factors. Length of marriage, incomes of the parties, those are the main factors, but there's about 16 total. So as you can see, it's as far as support is concerned during your separation, it's all income driven. after that, they look a little bit more at the needs. And then just a note about counsel fees, because a lot of people ask me this when they come in for the first time. They've had friends that have, talked about one party paying the other's counsel fees in a divorce. And in Pennsylvania, it is certainly possible to raise the claim, and I've had cases where that's happened. But unless there's some kind of bad conduct on the part of one of the parties, counsel fees aren't traditionally awarded in the greater Philadelphia area anyway, in our counties around here. So I want to just kind of wrap up with a tip. The best thing that you can do is to try to sit down at the kitchen table with your spouse. Say, these are our assets, these are our debts, here's what I need to live on, and figure this stuff out yourself. Use the attorneys to draft up an agreement. And if you need help, certainly go to mediation, and Bill will talk about mediation in that process in a minute. And the worst thing you want to do, though, is go to court. Use that as a last resort. A lot of people think that you get your day in court and justice will be served. That's really not usually the case. So to the extent that you can work it out, either by yourselves or through mediation, I would definitely encourage people to do that. I want to turn it over to Bill, who will talk about mediation specifically. Bill, would you like to introduce yourself and tell us a little bit about what you do?
Sure, thank you, Drew. My name is Bill Donahue, as Drew said. I am a divorce attorney and a divorce mediator. I work in South Jersey and throughout the greater Philadelphia area. I've been doing divorce mediation for almost 20 years now. And what mediation is a process or a method for resolving really any kind of dispute. There's international mediation, there's business mediation, and what I specialize in is divorce mediation. What I do as a mediator is help the couples that I work with to explore and identify what their real interests are, what they need, and what will help them to move forward after the divorce. I ask them questions like, where do you want to be 6 months from now, a year from now, 5 years from now? I ask them what kind of relationships are important to them, their family, their friends, their children, their relationship to the community, what relationships do they want to maintain, or what relationships do they want to repair? By looking at the financial issues, the parenting issues, the support issues, in that way, it enables people to figure out what's best for them in a particular circumstance. And for most of my clients, it takes between 6 to 10 hours to do this. And then they go forward, usually have their agreements reviewed by counsel, separate counsel, and then one of them will file for divorce and they go forward and get a simple divorce.
Bill, can you tell us about maybe some of the benefits of mediation, especially in the context of a divorce?
I think one of the greatest benefits, divorce is, as you know, certainly is very emotional, often very hostile. The people come into the process not always at their best. And when you separate them, and which is what happens in the litigation process, they lose touch with each other, they lose touch with the relationships that they've had, that they want to have in the future, and it tends to escalate the anger and the hostility. The mediation process, the couple sits down together, and I work with them. They talk to each other. They talk to me, of course, but I try to keep them primarily focused on talking to each other, and it enables them to realize not only what they need to go forward, but what the other party needs to go forward as well. And they tend to be able to come up with solutions that meet their needs for both of them. And that's why resolving these kinds of highly emotional issues through mediation tends to work very well. Statistically, people who mediate their divorces tend to abide by the agreements that they reach in far higher numbers than people who have decisions made for them by masters or by the court. And people tend to be happier with agreements that they've authored themselves. And for many people, it's a very empowering process. They come through the process feeling that they've done it themselves.
Now, I've heard some people say that their case is too complex for mediation. Are there cases that are really too complex?
You know, there really aren't, Drew. And the reason for that is that we use the same resources in the mediation process that we would use in the litigation process. There are many cases that are relatively simple, and you don't need to marshal these resources. But if you have cases where there are very complex financial arrangements, where there are businesses, particularly if there are cash businesses, we use all the same kinds of experts that our group here is made of, for one thing. We use business evaluators like Mark. We use realtors. We use certified divorce financial planners to help people, whatever the issue is, to come to understand it. With complex cases, we tend to have lawyers involved throughout the process, whereas with simpler cases, we tend to only have lawyers involved in the process at the end. But the point is, any case, no matter how complex, we can find the professionals to put together a team that will make the process work for them.
Okay, Bill, is there anything about mediation that makes it particularly helpful when we're talking about dividing up assets and personal property in a divorce?
There really is. Part of it is what I was talking about before, where we have the couple sitting down talking to each other is a big help. But the distribution of property, particularly personal property, is something that people often use to get back at each other, to hurt each other. It's not uncommon to have a particular asset. One that I use as an example when I teach mediation is that you have a sailboat that one spouse spent all their time working on and enjoying, and then you get to the table to negotiate a settlement, and that's the thing that's on the list for the other person. Or a house is a very common one as well. So if you can get people to look at what they need going forward and diffuse some of the anger, they tend not to go after the pieces of personal property that they know mean the world to the other side. So that's where this becomes really important, is helping to diffuse the anger.
Okay, great. Thank you very much, Bill.
Sure, thank you.
Valerie, I want to turn it over to you. Would you like to introduce yourself and tell us about your business?
Sure. Hi, everyone. My name is Valerie Clark-Roden. I'll give you a little background for anybody who may have missed the last call. I work with Hoteling Investment Management and Wealth for Women. Our firm plans and invests for individuals and organizations, and through our Wealth for Women program, I outreach to women in transitional stages such as divorce, retirement, or widowhood, along with our expert research analysts. We have portfolio managers and a financial planner, and we create income and growth for their investable assets. We have a special focus working with divorced women. We get them on board to investing for their new lives and their independent futures after they receive their equitable distributions. And later on in another seminar, I'm going to talk a bit about investing equitable distributions. Our process is inclusive, and by this I mean we educate our women clients through steps of planning and investing so they can have a full understanding of their financial landscape. We want to show them, how to do this and what we're doing. We're not just taking their money and investing it for them and patting them on the hand and telling them to go away. I mean, really, we want to educate everyone who comes through our Wealth for Women program.
Okay. In your experience, Valerie, how are families' assets typically held?
Well, I see typically in my business, assets are held jointly or in joint name, individually in trusts, pensions, IRAs, 401ks, real estate, and insurance. And those are just the main basic ways that we see assets held. I'm not going to talk about real estate. We've got Kay Pugh from Keller Williams. She can talk about that later on. And we've got Allie from JKJ Insurance, who can talk about insurance holdings. These assets may be invested in stocks and bonds or in retirement, which are generally tax-free type of investment accounts. And all of these assets that I've just mentioned may be considered part of the marital pot of assets. There's a lot to cover here, so I'll just gloss over just a little bit about some of these main basic accounts that we see where families hold their assets in my business. So there's a joint account. And a joint account is held by 2 or more people. And in most cases, I see these accounts owned by spouses, and they're set up with what's called with rights of survivorship. You might see at the end of a joint account title, joint account, and says WROS, with rights of survivorship. And this type of the account, ownership is equal between the 2 spouses. However, either person can contribute more than the other. So one spouse may be ACHing or electronically delivering their monthly paycheck, and the other one may not put anything in it. But it is supposed to be an account where assets are owned by each person equally. The surviving spouse is going to become the owner of the entire account upon the death of the other spouse. There are other types of joint ownership. If you want to go into those, please give me a call. I can talk more deeply into the type of joint accounts that are not just with rights of survivorship. There are also individual accounts. There are also individual accounts which are owned by one individual, and investment assets are often held in the name of each individual spouse. Drew, did you want to say something?
Yeah, I just wanted to ask, I was talking a little bit before about identifying and valuing the marital estate. So kind of in the beginning, we need to identify the marital estate. I was just curious, in your experience, what kind of information can someone get on their own without even having to, start through the divorce process, but if they want to gather information on their own?
Sure, exactly. So they can get monthly statements, transaction, trade confirmations, that sort of thing. However, I do want to say that everybody's getting all this stuff electronically now. I'm sure everybody on this phone would agree. There are not a lot of people who are getting this in hard copy. So I did a little research recently on how far back our clients could view their statements at my firm, and the custodian who holds the assets for our clients and who actually print out the statements and all other paperwork said that it is viewable up to 2 years, and then after that they can provide a statement, trade confirmations, and tax documents up to 10 years without any additional charge. It would just have to be, you just have to go to that custodian and ask them for that information. Further back, I think a lot of firms are going to charge a research and archive fee, which could be an hourly fee depending on what specifically you're looking for. I went online and I went to my bank account, which is Susquehanna, soon to be through a merger, or I think BB&T bought them. They said I could view my statements back 24 months, but after that, they said that they would charge me $5 for each statement, or that I would order after that. And heavens knows, when you have those mergers with the banks, there's not necessarily an easy transition. So hopefully all my information will transfer over to BB&T. Mark, you went on your bank website, and I think you found that your credit union went back quite far. So did your business bank account at PNC. What did you find?
Yeah, my personal account, which is through a credit union, actually went back to January of 2002, which kind of surprised me. I didn't look to see how far back I could go to get check copies. I'm assuming it's only a year because that's typical. But my business account went back 7 years. So, I mean, there's a lot of information out there that you can get to if you need to.
It really can be tough, and with so many of us accessing our financial information online. So the big question is, how then can you access your spouse's financial statements? Discovery, the second D word in this process, is where both spouses are to make available all documents pertaining to their joint and separate assets and income. That includes debt. Drew, what has been your clients' experiences obtaining financial information from their spouses?
Well, not surprisingly, people don't get along in divorces, and they don't always like to give up their information voluntarily. So as an attorney, I can send out a subpoena, and unless the other party objects with legitimate grounds, the banks or financial institutions have to honor the subpoena and provide the information. But that can be costly to the client, because then you're incurring legal costs, and a lot of times banks charge per statement, like you were talking about a minute ago. You can also do a request for production of documents, which is just a fancy term for you're asking the other side to provide their information. And they do have to do it, but if they don't, you have to go to court and fight about it. So what I always say to clients, the first thing for any joint accounts or accounts in their name, they have access to. If you can't get it online, drive to the bank and they'll give you the statements. That's a great place to start. But that's not always the case. A lot of times assets are held by the other party, so then you do have to go through discovery. And unfortunately, if the other party wants to be difficult, it can be difficult, but you do get it eventually.
And you do see cases where, both spouses are on the account, even though one doesn't do anything, like if it's a business account or something like that. Usually the non-moneyed spouse who would like to have access to this can usually just call the bank. Or if you have a relationship with the bank or with somebody in the branch that's locally, you can just ask them for copies too, and 9 times out of 10, they'll just give them to you.
Yeah.
As long as you're on the account, of course.
Valerie, you mentioned before how assets are titled. Can you expand a little bit on what that means as far as the marital pot for equitable distribution?
Well, assets are created generally or used during the marriage are marital, regardless of the title: retirement accounts, joint accounts, IRAs, pension, 401ks, individual accounts. That's, the ones that I mentioned before. All of these are going to be considered as part of this marital assets to be divided up. Some of the assets can be considered non-marital due to premarital agreements or trusts, but this, Drew, is definitely a legal issue, and I think I'm sure you can talk more about assets that are not to be considered part of the makeup of the marital assets from a legal perspective.
Yeah, just briefly, any assets, again, during marriage that you save or acquire during the marriage are marital, but there are exceptions to that rule. If you inherit money and you keep it in your own name, only the increase in value in that inheritance from the time you inherited it until the date of separation would be considered marital. The rest would be non-marital. Likewise, if there's a particular kind of asset that's excluded as marital property in a prenuptial agreement, then that's deemed to be valid, unless it would be set aside, of course, and that's non-marital as well. And some people choose to also, in a prenuptial agreement, exclude the increase in value on a particular asset as marital. So Valerie, is there any advice that you can give a client who's just starting the divorce process?
Well, make sure you have a safety net, have ready access to that cash that's yours and not controlled by your spouse. If you relied on both your and your spouse's assets, you're soon going to be relying on about half of that amount, or at least if that's what's agreed upon in your temporary support, it could be less. How are you going to live off that money if you get cut off of assets? A financial planner can help you identify your sources of income. On top of your salary, let's see, dividends, interest, Social Security benefits, pension, and retirement assets are all considered income. You're going to need to determine if these sources are going to produce enough income for you and your family to live on today and in the future. A planner can help you figure out what your burn rate is, if there's a gap in that burn rate, and how are you going to fill that gap. Do you know what you spend a year? You need to create a cash flow statement with your planner. Important items on the planner's list are going to be lining up your non-discretionary expenses such as groceries, utilities, credit card debt, loan, insurance, and don't forget taxes. And what are your discretionary expenses? These are usually things we want versus what we need. So cut up those credit cards. Pay attention to your retirement plan and taxable investments to make sure they're giving you the desired interest and return that you need right now. Find an investment advisor, just like us at Hoteling Investment Management, to help you with all of this. I couldn't resist that plug. Thanks, everybody.
Valerie, good advice. I'm going to turn it over to Mark. Mark, do you want to introduce yourself, please?
Hey, my name's Mark Bradford. I am a certified public accountant and a certified forensic examiner. I work for Steering Consulting. We're a small group of about 10 people, all former big accounting firm people who did litigation consulting with bigger firms who are now on our own. It's a much nicer environment, a much easier environment to work with as for our clients also. I have about 16 years of litigation experience. I've been doing family law for about 14 years now. My cases range from something small and simple to, somebody who just needs help figuring out the premarital value of the retirement accounts, postmarital value of stuff like that, to people who have hundreds of millions of dollars in the bank. It really ranges a lot, and the cases vary. You could have people who don't think that it's very complicated who can become complicated when you're trying to figure out cash flow from a small business or something like that.
Okay. Mark, what kind of documents do you usually look for from clients?
First thing I try to gauge is where they are in their stage of life. We see the short-term marriages who don't accumulate a lot of marital assets, and you see the long-term marriages, people who have been together for 40, 50, 60 years. I know 60 years sounds like a long time, but they do get divorced then too.
Yes, they do.
And it can be very complicated. So you really have to take it back a step to figure out where they're at and what they need. It could be a very simple document request, or it could be something very complicated. You have to figure out, and you also have to figure out what they know and what they have access to. Like Valerie was saying before, not everybody understands what's going on. Not everybody knows what they have. I've had clients who made $10 to $20 million a year, and they had no idea what assets they had. They didn't know where the money went, and you have to do some forensics to figure that out. And they were the ones controlling everything. So it's interesting to see, and you have to make sure that you get to the documents that you need to get there.
Okay. From a tax perspective, Mark, talk to us about alimony versus child support.
One of the things that I try to remind my clients that if they're the disadvantaged spouse, if they're not the money maker in the relationship, they're going to be getting some type of support payment. So it's going to be a mixture of alimony and possibly child support if they have children. And they have to understand that the portion that's allocated as alimony is taxable to them. It's not taxable to the person paying it, but it's taxable to them, and they're going to have to allocate money to pay those taxes throughout the year. If they're doing quarterly payments or annual payments, or if they're a W-2 wage earner, they need to beef up their withholding while they're receiving that support.
Okay, so do you assist clients in this stage of determining alimony and child support?
The court does what's called a net income available for support calculation. We take their tax returns and we try to figure out what's the true cash flow for the parties. Just because the numbers on the tax return doesn't mean it's cash available to them. Business income, K-1 income, it's not cash that's flowed to them, it's cash that's flowed through the business if that's what's there. Same thing with rental properties. You see a number on there, but there's depreciation mixed in. You have to correct for those things to the actual cash that came through. So I would adjust for the business income and replace it with distribution. The same thing with K-1s. If I'm looking at a rental property, I'll figure out what cash is actually coming to them in terms of the rental income, and then take out the portion of expenses that aren't really cash. Might be, long-term depreciation and things like that.
So in talking about net income available for support, what kind of information can you learn from someone's tax returns?
Tax returns are there's so much knowledge you can get out of tax returns. There's the 2 summary pages that give you an idea of what to look at. Is there something on the dividends or interest line? Are there things in the Schedule C that might be business income or something like that, and what's in there? Do they have a business? Do they have those rental properties? Do they have capital gains from selling assets such as stocks? You can really dive through and figure out what to ask for, going back to the first question Drew asked. What do we need? And I like to go back several years on their tax returns also to see if anything, if there was a gain, what happened to that money on that asset? Did it disappear? Did it get transferred to a brother, sister, parents? It kind of gives you an idea of what you need to look for to make sure that you understand everything that should be in that marital pot.
Okay, good place to start, I guess. Huh?
Yeah.
All right, Mark, thank you very much. I'm going to turn it over to Allie. Allie, would you like to introduce yourself and tell us what you do?
Hi, everyone. My name is Allie Collier. I work for Johnson, Kendall & Johnson, and I am in their private client group. We specialize in risk management approach to home and auto insurance.
All right, Allie, so at what point does insurance typically become an issue during separation and ultimately divorce?
Well, typically it becomes an issue when one of the parties moves to a separate residence, and then it becomes necessary to establish separate liability for each of the spouses. There's a process that needs to be observed by both parties and the insurance agent to ensure that one spouse doesn't end up having a gap in coverage.
So what generally comes up first that you see?
Typically, auto insurance is the first one that we have to untangle. Before the separate policy can be written, we must make sure the policy owner's name is on the registration of the car. If the ex-spouse is listed on the registration, that's okay. We can list them as an additional insured at no charge until that gets further straightened out. But when the car has a separate garaging address and one of the parties has moved out, it really needs to, at that time, take out a separate auto insurance policy. Be aware that sometimes rates change due to divorce or separation. That's a discount with many insurance carriers, as well as if you have 2 cars in the household and now it's going to be 1 car per policy, you may lose a discount there. So it's not always, a straight line. You were paying $1,000 a year under a joint policy, and that's what you're going to pay under a separate policy. When everything's completed with remarketing and moving the insurance, one of the spouses must sign a removal request to be taken off the other policy. So it's really clear that your insurance agent makes this clear to both parties up front. Sometimes I've seen where you get a duplication in coverage because one of the parties refuses to sign the request, and just make sure that's something that you know up front that's going to need to be accomplished.
Okay. So once the auto insurance is separated, what's next usually?
Well, the relocating party might be renting, and they'll need to consider what's called a tenant's or renter's insurance policy to cover your belongings at the new property. A lot of times your landlord will require that you take out this kind of insurance. If you moved some paintings or some jewelry from the primary or the marital residence to the new location, then they'll need to be insured as well under your own policy. And if you had an umbrella policy in place with your spouse at this point, you would want to take out coverage on your own as well.
Okay. So what about the marital residence then?
This is typically the last policy that we make changes to because it's part of the separation agreement, and that's not something that's usually ironed out right in the beginning. If an ex-spouse remains on the deed, they would need to again be listed as an additional insured until their name is removed. But many insurance companies will require that a new policy be written at the time that the one of the spouses takes ownership. They look at it as if it's a new owner.
Okay. So what should someone going through a separation and divorce look for in their insurance agent?
Well, you want to work with someone that's experienced. Divorce is a very emotional process, and working with a professional who knows how to handle separating your policies will make your life easier. I've seen some nightmares with fights between spouses and an agent, unwittingly saying something that they shouldn't have said to one of the parties, and you really want to work with someone that you can trust, who understands that this is, a private, separate issue now for each of the spouses, even though they may not be formally divorced. It's no longer a joint policy. You want to work with someone who has access to multiple insurance companies. The carrier that was the most appropriate coverage for you as a married couple may not be that same, the best carrier, the best choice for you after you're divorcing. So it makes it easier for you if you can just make that phone call and the agent takes care of everything for you. And sometimes your insurance agent can be a great resource to you. They may have a network, a mortgage professional, a real estate agent, or an investment management who can help you as you're looking to maybe make some changes to who your advisors were in the past as you move forward. So it's good to have a relationship with your broker, your insurance agent, that you can really talk to and explain what needs you have going forward.
Okay. Great. Thank you very much, Allie. Ken, I want to turn it over to you. Why don't you introduce yourself? Ken, are you there?
Yeah, I'm here. Oh, can you hear me?
Yes.
Drew?
Yes,
All right,
I hear
sorry.
you.
All right. All right. Hey, everybody. I'm Ken Feynman. I'm with Approved Mortgage Group. I'm a mortgage lender. I'm a federally chartered bank, so I'm licensed in every state to do business. And what I do during the process is, one, I can help people either secure a mortgage for a purchase of a new home, or I can help refinance the current home if we're looking to remove a spouse from the current mortgage. That's pretty much what I do as far as where the mortgage process goes. You're going to want to get with a mortgage person early on in the process because there are lots of new rules and guidelines that people don't even think of.
So, Ken, if I'm going through a divorce and I want to keep my home, what do I need to think about and keep in mind?
Well, what you want to keep in mind is now that you're going to be the only one paying the housing expenses, you want to make sure that you can afford the housing expenses. So I normally like to meet with people early on, especially if there's no property settlement agreement put in place, to kind of get an idea of, all right, here's all your bills, all your expenses, the mortgage payment, utilities, everything. Are you going to be able to afford it on your own? What are you guys projecting as far as alimony or child support? Are you going to be refinancing the house into your own name, and do you qualify? So those are the things that you need to look at if you're going to be staying in the house.
So I know that my spouse is going to be entitled to share in the equity in the house in the divorce. How is that handled usually?
So normally an appraisal is done, and whatever you owe on the house minus the value plus whatever, if you're going to be selling the house, there's usually, realtor fees and other transfer taxes and things like that. Whatever's left over is what the two people have to split. So when we do a refinance, we're going to get an appraisal of the home. We're going to see how much the house is worth. We're going to refinance the current mortgage, pay it off, and sometimes you can get cash directly right out of the house to pay the other spouse. Or sometimes if the other spouse is not on the mortgage and you don't need to refinance to take somebody off, sometimes you can just do a line of credit to pay that person, or you can take cash from other assets in order to stay in the home.
Okay. Well, then what if I'm the one that's leaving the house? What do I need to consider then?
Well, if you're leaving the house, you want to consider that you're still currently, if you're on the mortgage and you're currently still obligated to the loan, that's still going to affect your credit. And if the person who's staying in the house doesn't make the mortgage payments, that's going to negatively affect your credit, pull down your credit scores, and could also prevent you from getting a new mortgage on a new house if you're looking to purchase a new property. That debt will be counted against your total debt ratio and your ability to get a new house unless we can show proof that the other spouse has been making those mortgage payments for 12 months, or we refinance and take you completely off of the mortgage and it's no longer in your name. Those are the things that I see cause the most problems, after somebody moves out.
What if I want to purchase another home before the divorce is actually finalized? Is that an option?
Yeah, it's definitely an option. There's a couple things to consider when doing that. If you're going to be looking to use either alimony or child support, we need to make sure when it's alimony, we have to make sure that the alimony is going to continue for at least 3 years before I can count it as income. And I also have to show that you've been receiving it for 6 months. So it doesn't matter if the divorce is finalized, if a property settlement agreement is in place, but I do need to see that you've been receiving alimony or child support. Both have been received for 6 months. And you're going to want to show it out of a separate bank account, too. If it's a joint account, there's no way for us to tell which spouse is actually giving the other money. So you want to actually have it from separate accounts so we can follow the paper trail, either follow the canceled checks or follow the deposits. And that can happen anywhere along the way. So like I said, it doesn't have to be a divorce finalized or a property settlement agreement. However, we are going to want a letter from both parties signed and an attorney to sign that says this is what the alimony could be, or you're not going to be paying any alimony. We have to make sure that whatever it's going to be, or if you're not going to pay anything, that we include it in the debt ratios to make sure that you qualify. But we do that all the time for people.
All right, great. Thank you very much, Ken. Good information. And last but certainly not least, Kay Pugh. Kay, do you want to introduce yourself and tell us what you do, please?
Yes, hi. Can you hear me okay?
Yes.
Great, perfect. Yes, my name is Kay Pugh. I'm with Keller Williams in Bryn Mawr, PA, and I've been with the company for about 5 years, specializing in residential real estate sales. So, getting to the topic here, I have worked closely with buyers and sellers in the divorce arena. As Ken kind of touched upon, as far as the mortgage is concerned, it's a little bit of a different story when you're buying, obviously, and selling. So you have to definitely have all your ducks in a row. I think I want to get back to what Bill was saying in the earlier part of our conversation about really getting down to what the couple's interests and or needs are. This is really, hashing that part out is really, I think, the first step in getting focused on, where are the kids going to be? Is one spouse going to take over the mortgage, take over the house, or does it make sense to sell the property? And in making this decision, I think it's really important to to get through that mediation, really before before I come in. As Ken was saying as well, typically when you're looking at a refinancing option, you're looking more towards getting an appraiser to come out and do an official appraisal of the property. If the property is going to be sold, however, I certainly provide all my clients with a comparative market analysis. All my listings get that, and it basically just goes through the relevant comparable properties that have sold within the last 6 to 12 months in and around their hyperlocal area. So it's very important to figure out whether or not that property is an asset or a liability, because if it's a liability and the value hasn't increased, then obviously the couple could potentially end up bringing money to the table to get the property sold in a timely fashion. So really, the appraisal or the comparative market analysis is extremely important, and it's what I've found is really important is to work with someone who really knows your area very well, because the location of the property and the comparable properties that have sold around it are going to be a clear indication of whether or not the property is an asset or a liability to the couple.
Okay, great. Thank you very much, Kay. We appreciate it. And that's going to conclude our seminar for today. And again, just a reminder, our next teleseminar is December 3rd, 2015 at 12:15 p.m. And that will be discussing child custody issues. Thank you, everyone, for tuning in.